criminal defense attorney, Neil Rockheim.
Hey everyone, I'm Neil Rockheim. I'm a trial lawyer and criminal defense lawyer in suburban Detroit, Michigan. I'm called the Rockweiler because of my unique courtroom style, and I love trial lawyers. Over the last several weeks, I have had the privilege, the honor to interview and to talk to and to go one-on-one with some of the best trial lawyers in America, with some of the best trial lawyers over the course of the last 20, 30, 40, 50 years. Lawyers like Jeff Lichtman, Mark O'Mara, Mark Garagos, Lisa Bloom, Norm Pattis, and even a legend like F. Lee Bailey. I've had the chance to probe them and to talk to them about some of their major cases, some of their career highlights, some of the best things that they've done, some portions of cross-examination, some war stories. And I've been able to talk to them about these different aspects of their career and talk about how they handled certain moments, how they described their style, how they described their lawyering. You see, people tune into CSI or Law and Order or Dateline or Court TV, and they're looking for real crime, true crime. And they often hear interviews with these lawyers, and I want to bring you those interviews. I want you to hear from those lawyers. I developed a style of cross-examination that has been called killer cross-examination. And one of the things that I pledged to do was to not just bring to you the styles of other lawyers, but I want to bring you my style. I want you to hear about how killer cross-examination and how I use cross-examination and I use my style in court to attempt to reveal interest of a witness, bias on the part of a witness, and a witness's motive. All the things, bias, interest, motive, all the things that cause us to doubt whether a person is being truthful or whether a person is believable. I want you to hear, and I wanted you to hear from these other lawyers, these legends, these incredible lawyers who've handled high profile cases. I wanted you to hear from them, to hear how they've approached different moments in court, because I wanted you to get a sense of the way that, not just to watch it on Court TV or to watch it on Dateline, I wanted you to hear it from them in real time and hear how they handled certain moments in court, because those moments are better. They're having them describe it. These are the lawyers that you would see on those TV shows. And I'm proud that these lawyers have chosen to take time to speak with me, to talk to me, and to share their experiences with me. And I too have had similar experiences, and I have applied my style of cross-examination in the courtroom. I've applied the killer cross-examination in the courtroom. So I want to talk to you a little bit about how it is that I go about, how it is that we go about setting a trap for a witness. How do we get a witness, a professional witness, like a police officer, to reveal, an expert witness to reveal that he has a bias, that he has a conflict of interest, that he has a potential motive, that he's potentially being untruthful, or that his testimony in this case is questionable, or in a case is questionable because of his bias. How do you get a witness, a professional witness, to do that? Because the witness is not going to just answer a question like, are you biased? And they're not just going to say yes. You can't just ask the witness, well, professional witness, are you biased against my client? Are you biased in favor of the government? They're not just going to concede that. They're going to oppose that. They're going to fight that tooth and nail. And so as part of the killer cross-examination, as part of what I have advocated as my style of cross-examination, I have encouraged people, lawyers, to take a step back, think about the witness, and you have to lay all the information, all the evidence out that you have, and you have to do your own sort of, I don't want to say cutting and pasting, but because the witness is not going to write a report saying I'm biased, I have a prejudice in this case for the prosecutor against the accused, you have to have a way of looking at the evidence and looking what's on paper and looking at it all. You have to have a way of looking at it in order to see it. You got to look at it like this, and you got to look at it from underneath, and you got to turn it. You got to see it from all different perspectives. You got to take it apart and put it together differently, and you got to put it together like that, or like this, or like that. You have to see it differently than the way it is written on paper or the way it's in a transcript. You need to be able to put it together in a way that tells the story through your questions and the witness's answers. And you need to do it in a way that actually sort of corners the witness to where they're forced to concede that they're biased. And if they deny that there's a bias, or they deny that there's a conflict of interest, when you put the ultimate questions to the witness, they're stuck. They're trapped. And they know it. Because if they say yes, there is a bias, there is a conflict, there is the appearance of a conflict, you've got it. And if they say no, there isn't, the facts that you utilize or the facts that you use to cross-examine that witness and lead right up to that point prove otherwise. They render that answer no, there is no bias, there is no conflict of interest. They render that just unbelievable. So I want to take you back to a story, to a case that I handled as an example of how I laid this trap, how I revealed that there was the appearance of a conflict of interest, and that there was a conflict of interest and bias on the part of an expert witness in an automobile accident homicide case. In 2017, I tried a case representing Charles Warren. It was a very high profile case. The case had garnered publicity nationally, if not internationally. It was covered in every newspaper, every station, every television station, big, small, large market, medium market, everywhere it was covered. Charles was we called him Charlie. He was a 70-year-old man who was pulling a trailer, like a landscaping trailer. And he was pulling a trailer up north to go help a friend move some things at a house in northern Michigan. And Charlie, the trailer did not have any lights on it. It had reflectors, but no actual electric light. So when he turned or used his turn signal or stopped or hit the brakes, there were no lights on the trailer. Now, one early morning, Charlie is driving. He's driving a Volkswagen, and he's pulling this landscaping trailer. And as he gets off of a side street and an exit to merge onto I-75, he feels a bump, a large bump. Doesn't see any other vehicles, doesn't hear any other vehicles. There's no evidence of headlights or turn signals or sirens or anything else. As he enters onto the expressway, Charlie's driving, and other drivers around notice that there is a spark, that there are sparks coming from underneath and beside his trailer. Charlie moves into the different lanes. He feels like his trailer is pulling oddly and not driving, not tracking normally. And after about 3.5 miles, going approximately highway speeds, he pulls off into a rest area. And he pulls into the rest area. And as he pulls into the rest area, he wants to fix the trailer. He drives by some other people there. And at this point, there are people on the road. There are other drivers on the road, people in the rest area, all who saw the sparks and the way that Charlie's trailer was pulling. And as he pulls into the rest area, he rounds a corner. He goes to work on the trailer to figure out what's going on with the wheel and the tire. And what he discovers, what is ultimately discovered, I should say, is that Charlie had been dragging a Michigan State Police trooper for 3.5 miles on I-75. 3.5 miles. He had no idea. The bump, as it turns out, that he had felt, that he thought was a Michigan pothole, or a pothole as he attempted to get onto I-75, turns out that his trailer had collided with a Michigan State Police trooper who was driving a motorcycle, a Michigan State Police official motorcycle. Now, Charlie had no idea that he's not cold-hearted. He had no idea that he had come into contact with or had a collision with a motorcycle. But the trooper, having been dragged for 3.5 miles, the state attempted, and then ultimately dying. The state attempted to make a case against Charlie, and they accused him of crimes that were akin to homicide. They charged him with reckless driving causing death that carried up to 15 years in prison. Leaving the scene of an accident, like a hit and run, causing death or resulted in death, that's a 15-year felony. These were crimes that were very similar, if you think about it, to manslaughter, which is a 15-year felony in Michigan. They're basically saying that Charlie knew, or had to have known, that he had been in an accident, and that because he knew or had reason to know that he was in an accident, and or had driven recklessly in willful and wanton disregard for the safety of others, that he was guilty. It was an intense case. When he was ultimately acquitted after his trial, as the jury read the verdict and read not guilty, not guilty, I broke out crying. But in that case, they had a state trooper who was the state's principal investigator. The state police has an accident reconstruction unit and an accident investigation unit. And these officers were the ones that actually did the investigation. And one of the officers specifically actually conducted it was the principal investigator, an accident reconstructionist in this case. And I saw an opening. I saw an opening to discredit everything that this particular trooper, this particular expert did. I saw an opening to discredit everything that this trooper, that this expert witness did, because he worked for the same department. He was a member of the same department, the Michigan State Police, as the victim in the case. He wore the same uniform. He had met him on one occasion. He and others had shared with him that he was the deceased trooper was a good guy, and they all, in a way, sort of, others had mourned the loss of this trooper, as they should. But I wanted to point out that I wanted to point out in court through cross-examination that the trooper's findings in the case, the expert's findings, were compromised by bias, by the appearance of a conflict of interest, and by the fact that he worked for the same department. I want to play the clip for you from that trial so you can hear how I developed the testimony showing that he was biased, or that there was reason to believe that he was biased, and reason to believe that there was an appearance of a conflict. Now, I want to set the stage a little bit so you can see how I ended up doing it. what we did in an effort to investigate this case is we ordered prior reports that this expert had prepared. And we ordered the reports to take a look at what this expert had done in prior cases. And we found that in prior cases, this expert had written reports that were 3, 4, 2, 3, 4 pages long. And in this case, the report that he wrote was 16 pages long. I wanted to take that fact, I wanted to utilize that fact to begin to develop that that this trooper and the investigation by the Michigan State Police of a person who was accused of killing and accused of a crime in killing a member of the same department, that created a bias, that it'd be like having a member of a referee, if you will, from the University of Michigan refereeing the University of Michigan Ohio State football game. That it'd be like having the person, a referee in the Michigan State University of Michigan basketball game, actually have been a former player at Michigan State. I wanted to reveal that having somebody who wore the same uniform in the same department created a bias, the appearance of a bias. And I did that not just by showing that they were members of the same department, not just by showing that they wore the same uniform, but I began that by showing that the reports, the length of the reports that this trooper had written in this case were 3 to 4 times longer than they were in the other cases. And I had more to question him about. And I want to play that for you now.
Investigates and assists other departments and officer-involved shootings and incidents, don't they?
Correct, yes, sir.
And oftentimes, the Michigan State Police is called in to avoid the appearance of a conflict where the local police officer is involved in an incident. Yes?
Yes.
The Michigan State Police is called in for a fresh set of eyes, right?
At times, yes.
Does Michigan State Police have a conflict of interest policy that you're aware of in a similar situation when one of its own members is actually injured or involved in an incident?
You asking for a policy?
Are you aware of them?
Yeah, we do have a policy that if one of our members of the state police is involved in a crash, whether it be serious injury or fatal, that we are to be assigned to the incident.
So the Michigan State, other departments, when one of their officers are involved in an incident, they seek a fresh set of eyes from the Michigan State Police so that there's no appearance of bias or conflict. But according to the Michigan State Police policy, is we investigate our own. Is that right?
Some departments don't, I guess, not all the time.
Would you agree that it's important to be?
Now, do you see what happened right there? I had established that the Michigan State Police is called in on other officer-involved cases and other cases involving officers or other cases in which there is a reason to have a fresh set of eyes, somebody who's not related to the department, and that they're called in to conduct those investigations when there's another police department or another police officer involved. And I established, and he agreed that they're called in to do that in order to have the Michigan State Police investigate a case in which a sheriff's department or a local police officer is somehow accused in a case or involved in an accident. And they do that so that there's no appearance of bias, no appearance of a conflict. But when I put to the trooper, when I put to this expert that isn't there a policy? Isn't there a policy that when the Michigan State Police is investigating or a Michigan State Police trooper is involved in a case, you guys do your own investigations? And he says, yes.
Absolutely.
It's important to be objective.
Correct.
It's important as an investigator to disclose upfront information at all of any relationship with one of the involved parties in a crash, right?
Yes, sir.
You work for the same department as Trooper Wolf, right?
Correct. Yes.
You had met him before prior to his death, correct?
I had met him once. Correct.
You shook his hand before.
Just introduction. Correct.
Now, do you notice that I am setting this witness up? I've asked him, it's important to disclose any relationship between you and any of the people who you're investigating, any of the subjects of the case, anybody who's another party or a suspect or a victim. It's important to disclose that. It's important to get that out in front, to own that, so that everybody knows the truth, so that there is no appearance that you're hiding anything. And I ask him whether or not he's met the victim in this case. He concedes that he has. He concedes that he met him, concedes that he shook his hand, even if he only did so to say hello, but he remembered it. He knew that he had. And the trap is being laid right here.
While you were investigating this with other Michigan State police officers, you had discussed your feelings about tragedy that Mr. Wolf had experienced. Am I right?
Specifically about Trooper Wolf? No.
Hadn't other officers shared with you their fondness for him?
Yeah, I'm acquaintances with a lot of the other motor unit guys. Sure.
Other individuals disclosed to you their feelings for his sadness for his family?
For his loss and family, yes.
And you wrote the 16-page.
Not only has he acknowledged that he knew Trooper Wolf, that he met him, that he shook his hand, but that he knew other members of the same division, the motor carrier division, the motorcycle division. And not only did he know them, but they had expressed fondness for him, and that other members of his unit and other members of that unit had talked about how sad they were. They had grieved together, and he was aware of it over Trooper Wolf's death.
In this case, yes?
Yes, I did.
And I think you told me before it took you several days to write that report, right?
I believe in the prelim it was, several weeks.
Several weeks, excuse me. It gives you time to think about what's put in the report, right?
Now I'm establishing that he wrote a 16-page report, that in that 16-page report, he'd given it a lot of thought, took him a lot of time, he had the time to think about what he was going to put in, what to exclude, what to include, what information he should include in that report. Remember, a few moments ago, I'd asked him, it's important to be objective and to own and include and mention if you have any relationship with any of the people involved in the case. Remember that? Listen to this.
One of the reasons, sure.
Well, I'm just saying you have time to edit it, review it, make sure that it contains the information you want it to contain, right?
Correct.
Make sure it contains all appropriate and necessary disclosures. True?
Yes, sir.
And in that report, 16-page report, you never once indicated that you knew Trooper Wolf personally. Isn't that true?
I didn't know him personally.
You never.
See, I put to him, you never once disclosed in that report, that 16 pages, that you had time to think about, that you had time to write, that you had time to ensure contained all appropriate and necessary disclosures. And you thought about it and mulled over and wrote, you knew the significance of it. It wasn't a 2 or 3 page report. It's a 16-page report. And you had time to put in everything that you needed to put in order to satisfy your obligation and all of your disclosures. And I put to him, but you didn't make mention that you knew Trooper Wolf. And he tries to dodge us here. Notice he tries to say he didn't know him. He knew him. He had met him. He knew who he was, and they had talked about him among his troop. Listen up.
Indicated you met him.
Pardon?
You never once in that report indicated that you even met him.
No, sir.
You never once indicated that you and any other members of your department had discussed their fondness for him or had discussed their sadness for his family. True?
That is correct, sir.
There's no disclosures of any kind in your report. Am I correct?
That is correct.
Now, you didn't remove.
Do you see that he's caught? This witness is caught. He can't go back and attempt to justify why it is that he worked on the case. He can't go back and attempt to justify why it is that the Michigan State Police investigated their own. He can't go back and look at why it is that the Michigan State Police, this particular unit, why it is that he can't go back and change the fact that he knew who Trooper Wolf was, that he had met him, that he had shook his hand, that members of his unit and other he knew members of Trooper Wolf's unit, and that there had been discussions between he and others about their fondness for him and their grieving, all of which should be in a report, all of which should be open. He had already acknowledged that disclosures of that sort should be made. He'd already acknowledged under oath that those things should be put out in the open. He'd already acknowledged that all of those things should be owned and should be acknowledged and accepted. But in that 16-page report, no mention that he knew Trooper Wolf, no mention that he had met Trooper Wolf, no mention that he had shook his hand, no mention that he even knew who he was, no mention that that members of his unit knew members of Trooper Wolf's unit, no mention that they had grieved, all of which is evidence of bias, all of which is evidence of a relationship, of feelings that an investigator would have towards the victim, all of which should be disclosed so that the public, the court, the prosecutor, Mr. Warren, and the defense all know going into it that these men know each other and they were fond of him and they felt bad.
From the investigation, nor did the Michigan State Police, right?
Correct.
Other departments do have accident investigation crews, don't they?
Yes.
Sheriff's Department has one.
Yes.
Wayne County has one.
Sheriff's Department, I'm not sure if they do.
The FBI has one.
I don't know of it, but
Yeah.
maybe.
NTSB has one. NHTSA has one.
Sure, the federal agencies, correct.
Did you recommend at any point in time, because of the potential of the relationships that between the Michigan State Police and Trooper Wolf, that anybody else in the department actually get involved in the investigation?
No, sir.
Now you see, we've now come almost full circle. The Michigan State Police has brought in, as this witness has acknowledged, to look over for a fresh set of eyes, to be objective in cases in which other departments and other officers are involved in accident fatalities or accident crashes. They're the ones who are brought in. They're the ones who are brought in to be objective, to say, well, we're not part of the same department. The Elmtown Police Department, whose officer was involved in an accident, they're not investigating their own case. They're having us do it so that we can assure you that we have no connection to the Elmtown Police Department. We have no connection to the officer involved. We don't even know who that person is. So we, the Michigan State Police, are brought in to do that job, to be objective and to lend an objective, impartial accident investigation and to do an impartial investigation altogether. But remember, they can't say that here because they did the investigation. They claim that their policy is to actually do the investigations, even in which Michigan State troopers, even in which these officers have heard of the officers who are involved, may have met the officers involved, or knew of other officers who work with them. They're just going to forge ahead. And what I'm doing here, as you can tell, I'm establishing now, almost coming full circle, that there are other agencies that have accident investigators that the Michigan State Police could have brought in to do the investigation, and other agencies that they could have brought in to oversee the investigation, or at a minimum, just to fly spec their work to make sure that no bias, no conflict of interest invaded or interfered with the findings in the case. Listen on.
How about oversee your work? Would you recommend anybody else to come in and oversee your work to ensure objectivity and impartiality?
Outside of peer reviews with my counterparts, along with Sergeant Lucidi, who was out there, and Sergeant Stone, no.
His counterparts he's talking about are also Michigan State Police troopers, people in the same unit. And we had already sort of closed that door, saying that they're all part of the same unit. They all wear the same blue. They're all part of the same team. They all knew each other. So the only thing that this expert can do is attempt to say, well, I did talk to others, my peers, but his peers have the same issues, the same potential bias and conflict of interest issues that he does.
Those are also other Michigan State Police.
Correct, sir. Yes.
Would you agree that handling the investigation in this case, given the fact that you're a Michigan State Police officer, at least met him on one occasion, discussed the tragedy of it all, that created a conflict of interest?
Now, you see, I put to him the question because I want the jury to hear the question. It's clear to me, and it was clear to those that were working with me on this case, that there was a conflict of interest. They're part of the same department. They wear the same uniform. They knew the same people. They had shook each other's hand. Others in his department were fond of Trooper Wolf and knew of him and grieved together with them in the department over Trooper Wolf's loss. All of that established a conflict of interest. This is the ultimate question, that if he says yes, he's admitted that there's a conflict of interest. If he says no, the answer to me doesn't seem very believable. This is the culmination of the setup. He's forced to have to choose between, yes, I agree with you, Mr. Rockheim. In hindsight, we shouldn't have handled this case. There was a conflict of interest, but he doesn't concede that. If he says no, then the jury has to evaluate whether that's a truthful answer. And that's exactly the point. That's exactly the position that I wanted this witness to be in at this exact moment in time, having to choose. Does he choose yes, which is believable, but sinks his credibility, or does he choose no, which is not believable in my opinion? And I didn't believe the jury would buy that either. Listen to his answer.
No, I don't think so, sir.
You can see that.
Now, my next question is going to really put him in the trick box, because my next question is, okay, don't you concede? My original question was, don't you concede after all of that, with all these facts, that this established that there was a conflict of interest? It was apparent to all of us on our side that it did. And I believe that it was apparent to the jury that it did, but he denied it. So now I'm one question away from attempting to force him to have to make a huge concession. And my next question is to him, don't you concede that it created the appearance of a conflict of interest? And everyone knows that even if there's no bias or there's no conflict of interest, the appearance of a conflict of interest is enough to taint this witness's investigation and to taint his findings. Listen to the question and answer.
Creates at least the appearance of a conflict of interest?
Appearance? Sure.
Do you see that? How could he deny that? That was the final question. He denied that there was a conflict of interest, And he thought he probably was out of that hole. He probably thought he had answered that question and that he was gonna get out of that by saying, no, there's no conflict. But I asked him the next question. Everybody knows that it's not just whether there's a conflict of interest or bias, it's whether there's an appearance of a conflict of interest or bias. It's the appearance that has the capacity to taint the investigation. And when I put that to him, he can't deny that how could he deny that there was an appearance of a conflict of interest? And as you heard, he admits it. He admits that there was the appearance of a conflict of interest. And listen to how this gets tied up into impacting the quality and reliability of his investigation.
When I say appearance, that means that just because of the relationships, the appearance of a conflict means that others could call into question whether you're doing everything impartially or objectively. Correct?
Correct.
And despite the fact that you know that there's an appearance of a conflict, no other agency, no other department is called in to oversee, give a fresh set of eyes to this investigation, correct?
No, sir.
Michigan State Police investigated its own.
Yes, sir.
Do you see how I ended up, how a killer cross-examination, the type of cross-examination that I am a proponent of, that we have developed, that we advocate? Do you see how we put that together? None of that was in a police report. None of that was written down on a sheet of paper. None of that was like in a line in a report or in a transcript where he admitted to any of that. None of that was something that was out there. We had to sit back and we had to take pieces of information and pieces of evidence and attempt to put that together in chapters of cross-examination to put this to this witness in a way that would reveal or force him to have to answer tough questions and have to reveal and admit the facts of the bias and the conflict. And then after he admitted the facts of the bias of the conflict, we put to him the question, well, wasn't there a conflict? And he says, no, but wasn't there an appearance of a conflict? And he says, yes. And don't you agree that that appearance of a conflict could taint the way people look at this investigation and whether it was fair? He acknowledges, yes. He's done. Done. He's done. How did we put that together? I put it together with the idea that I was going to take the length of the report that he prepared in this case. I mean, when I asked him these questions, you could hear a pin drop in the courtroom. Everybody knew that this was a huge moment in the cross-examination of this witness. This was their lead investigator, investigating one of their own, investigating a fellow member of the same team, so to speak, someone that he had met, somebody whose death was grieved by other members of his department, and the people in the unit had talked about what a good guy the deceased was, and that he wrote a 16-page report in this investigation. And in that 16-page report, longer than any of the ones that we had seen in the previous 4 or 5 investigations. But in that 16-page report, where he had time to prepare it, he made no mention that he knew, had met, had ever had any greeting with, or that anybody in his unit knew Trooper Wolf, a fellow Michigan State Police trooper. And on top of that, he was forced to admit that those 2 questions, don't you concede that there is a conflict of interest? He has a Hobson's choice. He has to choose between yes, and if he says yes, that completely compromises his case. But if he says no, which he did, you have to wonder, is that believable? Is that an answer that people can digest, that they can accept? And I put to you that the answer is no. knowing the victim, being a member of the same department, and having talked about him and excluding all of that information from your report, I believe is evidence of a conflict. And I believe that the jury saw that. But when he denied that, we were ready for that, because I don't believe the jury accepted that answer, that no, there's no conflict. And so the next question to him was, well, don't you acknowledge that there is the appearance of a conflict? And he was, because it was clear to all that there was the appearance minimally of a conflict of interest. And he had to acknowledge yes. And then we circle back to, well, wait, aren't there other departments that could have been brought in to fly spec your work to ensure that the appearance of a conflict of interest didn't affect and infect the investigation? Aren't there others that could have been brought in to do it, or at least look over your shoulder and make sure that it was all done according to spec, that it was all done right, that it was all done according to the book, that no findings were made that could arguably be made tainted by the relationship between, because you guys are all part of the same unit. And of course there are other departments that could have been brought in. You know, any department that has an action investigator, and there are action investigators in many local police departments and sheriff's departments and federal agencies, all could have been brought in to oversee the work, to do the actual investigation, or brought in to actually to at least oversee it, to make sure that, yeah, you know what, you didn't leave anything out. Everything you did was by the book. All the findings here are aces, but they didn't even do that. That, my friends, is how, using a killer cross-examination, how you take facts, put them together to tell your story about how a witness is biased or is conflicted or has a conflict of interest. It's not easy. People who think that there are few moments in court that occur like this cross-examination that I just showed you. There are few moments that are like Matlock moments, or Perry Mason-like moments, or Boston legal moments, where you just ask the question and the whole courtroom is like hanging on the one answer, and the witness on the witness stand goes, I confess, I did it, I confess. Very few moments where those types of Perry Mason, wham, bam, those kinds of moments happen in court. But once in a while, if you've thought through it enough, then things line up just right. You get a moment like this in cross-examination. At the end of the day, after a lengthy trial, I'll tell you that when I started defending Charlie in this case, I would encounter people on the street, or in the courthouses, or at dinner, or at a restaurant, or at a bar. And I would just casually talk to them, and everybody knew the case. They all knew the case, because it was such a high profile case and involved so many different issues about a trooper and a really grotesque way of dying, you know, of course, being dragged to death, an elderly person who was driving, you know, some other drivers on the road, sparks, motorcycles, trailers without lights, all these different facts that were just, and people knew the case, because it's so unusual and it's so grotesque to hear about a person, particularly a hero, a trooper, being dragged on the highway for 3.5 miles to his death. Everybody knew the case, the trooper dragging case, the trooper dragging case, the dragging trooper case. Everybody knew about it. And they would hear about it, and people would say to me things. It'd be like, I would say, yeah, they're actually charging him with, they're prosecuting him. They're charging Charlie with a crime. And people's reaction would be, you don't want me on that jury. They'd go, oh, I feel bad for him. And I would say, oh, so you would find him, you would acquit him and find him not guilty. Oh, no, you don't want me on that jury. And so we knew what we were up against. We knew that this was really a capital case in a way for the 70-year-old man, because he would have died in prison if he were convicted. And we believed, and I believed, that he was wrongly accused and wrongly charged. But we had to be able to come to court with the receipts and show it. And one of the ways that we were able to do it was to go through that cross-examination that I just played for you now. That portion of that cross-examination. Some think back to my cross-examination of that expert, that trooper, and they think that that was the moment when the case was won. And I'm very proud to say that at the end of that case, the jury did acquit Charlie of all crimes. And I did break down crime because of the stress and the pressure and the belief that he had been wrongly accused and that he was being scapegoated. And I've looked back at different moments of that trial, and I think to myself, those were some huge moments. And our ability to construct those traps for that expert witness that I just played for you are part of the preparation and the execution that we were able to bring to bear in that case. It was an incredible moment. It was one of those moments where, as I am questioning the witness and I'm obtaining these answers, that my co-counsel are looking at me and their eyes are up and they're like, wow, this is really going down. Not going down in a bad way. This is like, he's doing it. Rockkind is doing it. The killer cross-examination approach is really doing it. We are revealing that there is at a minimum, the appearance of bias, and nothing was done to minimize it. Nothing. And I believe the jury saw that. The jury saw exactly that, just that the Michigan State Police had investigated its own, and that he had been charged, and that he shouldn't have been charged. And that I think they had another agency conducted the investigation, he wouldn't have been. So I have more in the coming weeks. We're going to go back and forth. We're going to have some other guests. We're going to talk about a whole wide variety of issues. If you want to see more of this cross-examination, however, of this particular expert, you can go to my YouTube page and you can find it on my YouTube page. You just got to go to youtube.com and find the Neil Rockkind channel. This cross-examination, you can watch it in total. It's called Cross-Examination Accident Reconstruction Expert, Michigan versus Charles Warren, Chad Wolf, Part 1. You can watch that. There's Part 1, there's Part 2. It's an incredible cross-examination. It's an incredible lesson, and I think there are some incredible teaching points for how to conduct cross-examinations of experts, particularly an expert who is identified with an opposing or who is, well, I'll just say with expert witnesses. It was an incredible moment in court, and it is on our page for all to see. But again, you don't have to go to Dateline or MSNBC or any of these other programs in an effort to see and hear about, true crime and to see real courtroom dramas play out. You can come to this podcast where week in and week out, I'm going to talk about these issues. And I'm going to play portions of successful cross-examinations for you, or talk to other lawyers who have obtained incredible results in some intense, high-profile cases. And you'll have a chance to hear from them. This is the Killer Cross-Examination podcast. It can be found at killercrossexamination.com. You can find it, again, on killercrossexamination.com. You can find it on YouTube, where we have videos of my interviews with these lawyers and videos of cross-examinations that I've conducted. You can catch it on Apple Podcasts, on Google Podcasts, on Spotify. You can catch different portions of cross-examinations and videos of cross-examinations and other cases that I've conducted on our YouTube channel, and you can just hear and learn and hopefully be entertained along the way by some of the stories that we bring you from the courtrooms. If you like the content, please subscribe, hit like, send us some feedback. But again, this is Neil Rockhind of the Killer Cross-Examination podcast, and I'll see you next time.